Law Collaborative presents Ron and Robert on Divorce. Here are attorneys Ronald Supanchik and Robert Borski with California Family Law. And welcome, Robert Borski with my partner,
Ron Supanchik.
And welcome to Ron and Robert on Divorce. And boy, do we have a great show again today. We are fortunate to have the Honorable Thomas Trent Lewis with us, and he has been blessing us with wonderful, wonderful information.
And we got into a little bit of a conversation, just barely touched on domestic violence. And of course, over the past 3-4 decades, we've seen huge strides made in the law with regard to an awareness and concern for domestic violence in family law. And Judge Lewis, I'd like to ask you what your thoughts are with regard to that particular subject and what your suggestions and advice would be to listeners of this particular show.
Well, I have a couple of things that I think need immediate consideration. The first is the lawyer's obligation to help the client develop a safety plan. The mere fact that you have a restraining order, as good as those may be, they are not really sufficient in high lethality risk cases. The client needs to have more than just a piece of paper and hope that that's going to keep them safe. And so I think having a couple of things happen. First, you need to have a good understanding of the risk of lethality in a particular case. And there's lots of good tools available for lawyers that I think bear looking at. One is a webpage that I would recommend. It's called dangerassessment.com, and it's just the two words, danger and assessment, and .com. The second is that they have a list there of 20 questions that you should be asking about risk of lethality and the danger to the client. The second is maybe a more profound book by Gavin DeBecker. He's been on the news and lots of talk shows. He has a book called The Gift of Fear, which I think is a very important book for lawyers to be aware of. So making an adequate assessment of the risk to the client and having a safety plan, I think those are very important, and I think that it may be, there are times when it's appropriate to say to the client, you know what, we could get a residence exclusion order here, but the perpetrator of the domestic violence could easily get into their own house. Everybody knows how to break into their own house. And changing the locks or, locking the windows, that may not be enough. And in some cases, the risk of lethality is so high, and the perpetrator of domestic violence frequently, the more they feel like they're losing control, the more likely they are to act out. That's quite documented in the research. So the lawyer making sure that even if the client says, well, we'll use the typical pattern, I just want him out of the house, that may not be enough for the client. And I think due diligence on the lawyer's part of making a real safety plan for the client is part of what I think is the lawyer's job. And by the way, that safety plan extends to the lawyer and their family. There are some perpetrators of domestic violence that want to go after the family law lawyer. The highest risk of domestic violence comes when the perpetrator of domestic violence feels that they're losing control. And the point at which they're losing control the most is when the family law lawyer becomes involved and takes away their victim and supersedes their authority, if you will. It's, of course, a twisted form of authority. And the perpetrator can very frequently want to take it out not just on their past victim, but anyone who is getting in the way of that. So I think lawyers have to be particularly careful about how they handle the domestic violence case in a variety of different ways. First of all, my recommendation to the lawyer who's handling the domestic violence case is to maintain an appropriate level of representation without being a source of unnecessary escalation. And so if you get into the heavy domestic violence case, sometimes we lawyers, as lawyers, we feel that it's our job to, be the rescuer. And, of course, that's part of good representation, but it's easy to let that go too far and become enmeshed in the client's situation. When that happens, law enforcement knows that any act that escalates violence is, if you respond in a way that's going to escalate, then it's not going to reduce the amount of violence, it's going to escalate the amount of violence. And lawyers' attitudes about the domestic violence case, without being wimpy, I'm not saying being wimpy, I'm saying just being appropriate is an important consideration. And I think that's something that the lawyers need to look at, their tone within the courtroom, their method of handling the case, the advice that they give to their client about having an adequate safety plan, and not failing, and making sure that you pay attention to the markers of the likelihood of an escalation of the violence. If somebody makes threats, then they have to be taken seriously, frankly. We talked about that earlier, where the question was, the guy says, I'm going to kill the kids, and I'm going to kill her. We had a case like that, it was on a recent episode of Dr. Phil, horrible, tragic situation where the judge, frankly, didn't pay attention to some of the risk of lethality, and a dad said he was, in email, said he was going to kill himself and kill the child. The judge didn't pay attention to the evidence that was presented, and sadly, that father in that case did kill himself and took a little, under 2 years old baby boy. It's important that we're measuring that risk of lethality and we're acting appropriately. And I can say, there's times when I'm looking at the lawyer and I'm going, you are not, I don't say it, of course, I'm thinking it. A good judge learns when not to say something, but thinking, oh gosh, you're just making this worse for your client because and maybe yourself, because you're putting yourself into harm's way because of the attitudes that you're bringing to the table. So
this idea of physical safety is absolutely essential. It's a critical discussion, and as well as emotional and psychological harm that can be done. Now we're hearing about in the literature financial violence that is done by a party that has greater control of financial assets. Is that something that the courts are beginning to become aware of, and are the courts talking about financial violence by one party to another?
I'm not going to. I think yes and no. I think that the better way of recognizing how the court deals with that is to look at the statutes in our state, provide that at the DV hearing, the domestic violence hearing, the judge is encouraged to make orders about finances. You're right. Money is a great way of exerting control, and judges have an obligation to make orders under our Domestic Violence Prevention Act in California, to make orders that assure appropriate support and financial considerations. Of course, there's limitations if it's just a straight DV proceeding and you have no financial information. Developing that evidence takes some time, and good lawyers will make sure that the judge has that information available and press the court to fulfill its statutory mandate to make at least some kind of temporary order about finances so that there isn't more victimization. Many other states other than California have focuses in their domestic violence law where the focus is not just on physical violence but also on emotional violence. The California model is built more around risk of harm physically, and it's arguable that there's room for improvement in terms of understanding that, although we do have some case law in California that talks in terms of disturbing the peace of the other party. But the framework itself under our DV law is built, frankly, more around the question of whether there's physical violence or not physical violence, and that's an important consideration in terms of developing the case. I think we're getting good training for our judges in general in this area, but there's always, for all of us, of course, room for more understanding of the complexities of how domestic violence plays out. And money is certainly one of the vehicles that's used.
Thanks, Tom. And we're going to take a quick break here.